Well, holy cow, we finally made it to the last of these sessions of Corporate Law 101, An Entrepreneur's Guide. We're going into Section 3, Part 2, Corporate Formalities. As I said in the beginning of this series, there's an explosion of new lawsuits against businesses and LLCs nationwide. In 2014, there was a case in Illinois where the courts found that the breach of the corporate veil was the number one business law complaint, and that when filed, 45% of the defendants were losing. Now, I really felt that no business owner should lose their home over something as simple as corporate records. So I've made it my mission to educate business owners just like you on the simple steps to handling corporate records in the right way. What are these people who breach the corporate veil trying to do? Well, what they're trying to do is to break through the barrier separating the company's assets to get to your and the owner's assets, your personal assets. And by exposing your personal assets, you also expose those of other shareholders, members, directors, and there's even some case law that it involves third-party operators if they're sufficiently involved in the corporate structure. This is a real issue, folks. If you'd asked me when I came out of law school, I would have thought that most corporations at that time, you learned that corporations are basically artificial persons and separate and apart from their shareholders. In fact, the default rule under the American Bar Association's revised rule says that unless otherwise provided, the articles of a corporation, a shareholder or a corporation is not personally liable for the acts or debts of the corporation. But they have some big words, except for you become personally liable by reason of his or her own acts or conduct. And that's a broadening standard across the courts in the United States, Canada, the UK. Okay? Now, it's funny because you'd think there was a lot of case law. It's 200 years since we opened basically became a United States. But there's few doctrines that are shrouded in mystery or even litigated more often than piercing the corporate veil. Piercing the corporate veil, as I said, is the most litigated issue in corporate law. What are they looking for? Well, they're looking for the wrongful acts, or you're treating the company as your ultra ego. That is, that there's no real separation between you and the company. Now, the rights and responsibilities of a corporation are independent and distinct from the people who own it or invest in them. A corporation simply provides a way for individuals to run a business and to share in the profits and losses. But many business owners don't realize that the limited liability comes with a corporation and or an LLC is conditional. And I mean conditions. Okay? The conditions are called corporate formalities, and they're listed behavior that every business entity must follow to maintain the corporate veil that separates the business's assets from those of the business owner. Very important. You know, things that are involved here is you can't make payments to yourself. You can't and have to have exchanges of assets at less than, at market value. You can't do it at less than market value. You can't be commingling funds, I'll write a check from my account over here and cover another account over here and, deducting personal purchases off the credit cards, paying persons who really aren't working, like, your spouse or that special friend or the kids or illegals, okay? Hiding cash or cash revenues from the IRS. Now, if the majority owners basically screw the minority owners can come and get them and hopefully open the door to the personal liability that is inherent in the owner's wrongful acts, the majority owner's wrongful acts. Another thing that's happening is that the owners have been running up large credit card debt. They know they're underfunded. They have no reasonable sources of revenues. Their sales are not meeting quotas, things of that sort. And then suddenly and boldly, they go to declare bankruptcy and they go, fixed you, Mr. Bank or Mr. Investor. Those aren't going over very well right at the moment with the courts. Violating these corporate formalities can be as simple as not issuing shares, not electing the president, or commingling funds, as I said, without a proper loan approval. In the eyes of the courts, such violations may be enough reason to remove the limited liability that separates you from your business, especially where they're annoyed with what you're doing. When a corporation is a sham or engaged in a fraud or other wrongful acts, the courts have very little tolerance for the nuances and are really wanting and trying to find a way to get below the corporate assets to get to your personal assets to punish. Okay, if you used solely for the personal benefit of the directors, officers, or the shareholders, that's the alter ego that we talked about. You really don't want to be doing that. Now, courts can pierce the veil that the law uses to divide the corporation and its liabilities and assets from the people behind the corporation, and they can disregard the separate corporate existence and impose personal liability on you. And they can do it on a lot of people. Now, how does this personal liability ensue? How does it come to be? Well, it results from the acts by the court to pierce the corporate veil will be that the individual running the company, and in many cases the shareholders of the company as well, will be subject to the liability to those who have been wronged by the company. So they'll try to bring the people that were harmed whole back where they should have been had they not been harmed. And there's clear case law that this applies to LLCs as well. In fact, I was involved in an LLC recently in a law case where we were charged and they were looking to put in receivers in order to take over the business. It was a couple of minority shareholders, and they had all kinds of smoke, but not a lot of fire. But they made that smoke in the federal court look awfully good for an awfully long time. Took our clients a long time to defend themselves. And part of it was that they had paid some people they shouldn't have paid. They didn't have a lot of paperwork. They didn't bother to keep good records. They didn't have any of that documentation put together with people that weren't involved in the so-called scheme. Now, it turned out there was really no scheme, but it took us an awful long time and a lot of company and personal dollars to get them out of that issue. There's a lot of renewed attention to the doctrine of piercing the corporate veil. And why is that? Well, it stems from several developments in the business and in the law. And some of it is like with the Enron case, there was fraud, and the federal government put into place laws like Sarbanes-Oxley. In the state courts, where people were harmed by those same kinds of tactics by companies, there haven't been a lot of remedies, especially where they're done, where the corporations are done formally, things of that sort. But the rights and responsibilities of the corporation have been subject to greater political debate over the past decade as the economy continues to experience fallout from multiple rounds of scandals by corporations. So it's becoming more and more logical for the courts to look at piercing the company veil, and has earned a top spot for the most litigated issue in corporate law. That's not surprising. And we talked about the court claims to be reluctant to pierce the veil, yet they're on par with the rest of the country because they do so in about 50% of the cases brought. That's almost half the cases. You want to flip a coin and see whether or not you've found the right information, or do you want to do it right the first time? My argument is that it's a lot cheaper to facilitate doing the work up front than it is, you pays me now or you pays me later. And it's a heck of a lot cheaper to pay me now than it is to when your company breaks down in the middle of the highway, as they say. Next thing that I want to go through here is, I told you about an Illinois case of piercing the corporate veil. It's one of the more modern cases. It's a 2014 case in the appellate court. And here the court used two-pronged tests to kind of determine what the corporate veil was. The line between the interests and ownership was so blurred that it blends together and there's no longer a separation between the corporation. That's what they were trying to determine. And two was, did the parties who composed it and to hold the corporation as a separate entity would promote injustice or inequitable circumstances? They really applied 11 factor tests to the corporation. And these are very important, and I'm going to take a little bit of time to kind of go through each one. Inadequate capitalization. How did the company proceed if it didn't have the adequate capitalization? And was it simply, oh boy, I'm almost on the verge of I have money, but I hadn't quite come in yet, Judge, or no, I borrowed money knowing full well that I didn't have any, nor was I probably liable to get any in the reasonable future? Did you do simple things like issue shares? And we talked about these corporate formalities. That was number 3 on their list. Did you pay dividends? If you didn't pay dividends, then you're not really a corporation. Well, did you file for insolvency of the debtor corporation? Have you been functioning as real officers, or are your officers really a non-functioning entity? And that is that Billy Bob or Mary Jo owns the company, and they're the only ones that really have any involvement in the company on a day-to-day basis. And nobody, their husband or wife is a, open quote, end quote, director, or open quote, officer. You've never seen them. They've never signed anything. Those are big, huge problems for the courts to say you're not really acting as a corporation. I'm therefore not going to give you the protection of a corporation. Is there an absence of corporate records? And the big one, as I talked about, you cannot commingle funds. If you're going to have loans to each other, make sure they're formal. Make sure that somebody other than you is at least around acknowledging you're signing it as part of the process. I made up 6 notes right here, officer, IRS. No, you see they're right here, signed by you and still on fresh paper. Still, the ink is still undry. Come on now. If you did them with a notary public, or you did them with some board of directors who had a meeting, and you had the board of directors sign the knowledge that you were borrowing the money or lending the money to the company, now we're in an entirely different circumstance. There's third parties, there's testimony, and especially if you can then document that as part of your book and seal, which is why legal book and seal becomes a very important process. It allows you to have a place to stick all of that stuff, which is date stamped, time stamped, and encrypted. Another factor is, was there a diversion of assets from the corporation from one person to another, or to the detriment of creditors? Here's really important. Did you take money out of the company just before you went belly up? Did you and other persons take $200,000 over the last 2 years and didn't pay any of the bills? Those are the things they're going to look for there. Failure to maintain an arm's length relationship. I can't tell you how many times I have companies, well, Billy Joe owns Johnny Bob's, part of Johnny Bob's company, and those two, they just pass things back and forth, and I don't bother to file anything with him, and he doesn't bother to file anything with me. Those are not arm's length transactions, and the minority shareholders who are not involved are being harmed by that failure to have an arm's length transaction in the business. And then, is there really a corporation, or is it just your alter ego, or is it merely a facade corporation? It's very important. And you notice how many of those kind of intersperse with these overall ones as it relates to, they're trying to figure out whether you're a real company or you're not a real company. Next part of this we're going to go through is corporate formalities, best practices, and the conclusions that we've drawn from most of this data. First of all, you need to issue shares to investors. As soon as you get the money, you quickly, after post-investment, after the investment money has been received, you make sure that investment dollars goes into the bank in the company account, and that you issue shares and share certificates for it. You also need to worry about having adequate capitalization. It's always a problem for small businesses, but you can't have negative balances on an ongoing basis. Try to borrow money and then go belly up. You need to observe corporate formalities. Absolutely critical to the process. The book and seal needs to be available for inspection by shareholders, the IRS, etc. And a lot of times that needs to be done in 72 hours. How are you going to make up things in 72 hours? Pay dividends. Duly elect your officers. Do not commingle funds. Get your loans in writing with written approval. And don't treat your company as your alter ego. It's a rapidly changing landscape on piercing veil. That's why I've taken it upon myself to go out and try to train small businesses on this. This is becoming more dangerous to companies every single day in every state in the United States. Courts now are very open to looking at numerous factors to pierce the veil. Equity influence to debtors and shareholders and the IRS is extremely high, and they're trying to protect those equity people from harm. Again, the corporate formalities are critical to the completed and kept book and seal, now more than ever before. And by the way, it applies especially to single shareholder companies and single member LLCs. You'd say, well, why? I mean, I don't need to do that. Well, yeah, you do. You're the only person that can tell the IRS. But if you're the only one doing it and you just signed it and it's to your benefit, whoa. They're not, the IRS is not necessarily going to start believing you out of the box. You'd say, well, why is that? Well, the reason is that you're the only shareholder, you're the only one writing anything down, and it's to your personal benefit. Who do you think gets the benefit of the doubt? Not you. Okay? When they're in there looking, they're looking to see what you took and how you're a bad guy and did wrong. Now, again, if you've got a board of director member, an attorney, you've written it down, you had it notarized, it's in your book and seal program, and it was dated and timed when it was put in there, and it was put in there 2 or 3 years ago, those are extremely strong evidentiary things to show the court and to get yourself through those kinds of processes. The court's jurisprudence regarding the formalities with respect to corporation, however, does not generally rely solely on the failure to observe formalities as a basis for piercing the veil. They really look to fraud and what they consider injustice, wrongful acts. And I'm telling you, folks, those are becoming broader and broader terms. Finally, businesses and entrepreneurs need to be aware of the different risks in which the doctrine can be used to obtain jurisdiction over you and ultimately collect on a judgment against the individual owners, board of directors, etc. Piercing the corporate veil is such a fact-intensive analysis, and the court law varies widely from jurisdiction to jurisdiction. There are, however, what they call a few bright lines, and I've given those to you today. The principal rule of limited liability for corporations and LLC remains solid, but piercing the corporate veil remains now a growing exception, albeit a powerful one to the rule. Being an entrepreneur in your own company is rewarding and exciting, but it also requires you to follow reasonable corporate formalities or risk losing all your assets to debtors, creditors, the IRS, and even angry shareholders, ex-spouses, or employees. Thank you very much for taking your time. Appreciate the process, and until I see you again, that's all for now. Hey, congratulations. You have just completed the end of section 3 of 3. I mean, it's over. You're done. Congratulations. And hey, if you'd like a certificate, let us know at legalbookandseal.com. We'll print one up for you and send it off. We know that how much time it takes. We know how important this material is. And feel free to give us a shout. We'll be more than glad to make a certificate available for you. Once again, congratulations on behalf of all of us here at legalbookandseal.com. Bye-bye. These tutorials are copyright 2017 BrainTech CSI Inc., all rights reserved.